All right, now this has been an issue in the past. Some counsel have been prepared to disclose their names, others have not. Mr. Counsel has raised an objection about that in the past. I'm not sure whether he raises that objection today.
Absolutely. I'll be asking for the court's recusal if those names are not provided, because that brings into question. Your Honor has information that Your Honor has received from the prosecution, namely the name of the counsel, which I am not privy to.
Well, I know counsel who's appearing because they've appeared before me before, and I do know them.
Sure, and I need to be able to check, not particularly in this instance, but in every instance, I should be able to check whether the barrister has any connection with the magistrate. That's one of the reasons why the court record is available to all parties appearing before the court. I think it would be highly hypocritical if the court shares documents that I provide to the court as a party, copying other parties in, and the court shares it with people that are asserting an interest to be a party whilst not sharing information with me concerning the court record to which I'm entitled. It would bring into question the independence of the court. It is unconstitutional. I've given extensive material to the court that establishes that. I've also complained to the Supreme Court in relation to this. I will be here under protest if I'm forced to, just because the court is holding a bail over my head.
Mr. Counsel, I don't know how you can be here under protest when it's your subpoenas that have been filed.
I'm saying the court does not have jurisdiction in this proceeding, and when that is proved I will sue the court for misfeasance in public office for not first determining the matter of jurisdiction they have, Your Honor, that the informant in this matter has undoubtedly committed.
That's an application for another day, Mr. Counsel.
No, but the court has to determine jurisdiction before it orders me to do anything, before it chastises me for being late.
This is the first time you've raised the issue.
That's not true. The transcripts will show that I have raised the matter of jurisdiction repeatedly. In fact,
not before me. You haven't.
Your Honor, 2 hearings before, when I said that the whole search warrant thing brings into question the validity of the matter, Your Honor made a comment that even if the material was thrown out, all that means is evidence is thrown out, but that does not,
What I said was, if you have an argument in relation to the validity of the search warrant, that's a matter that can be raised. But that's a jurisdictional question. That doesn't necessarily go to jurisdiction. It goes to the possibility of an application under Section 138 of the Evidence Act.
But Your Honor, DPP v. Strickland respectfully establishes that where the origin of the proceeding is founded on an unlawful conduct by the executive, it is the duty of the court to not acknowledge the proceeding because the court cannot let the executive benefit from its unlawful conduct.
All right, well, again, I think that's an application that can be made on another day.
But the court cannot address me as a party in this proceeding when I am bringing into question the legitimacy of the proceeding. And at the very least, I think the court should take me seriously when I'm making submissions. The LSB is not a proper party in this matter. I think
All right, well, look, just take a seat. In relation to this issue of the naming of counsel, I will hear submissions as to the reason why counsel are refusing to give, all right.
Can we have, Your Honor, synonyms so I can add them to the or address them in the affidavits appropriately?
You can refer to them as counsel for the DPP.
Who is the counsel for DPP?
You can refer to them as counsel for the DPP.
May I get a face to associate with the pseudonym?
That's the gentleman who's immediately to Ms. Zhu's right, and then
counsel for the DPP, okay.
You have counsel for the Chief Commissioner.
The lady in the middle?
And then counsel for the Legal Services Board.
Which the court cannot acknowledge the presence of at this moment.
I acknowledge his presence for the purposes of his appearance, all right?
For the purpose of being heard.
Any determination about jurisdiction at this?
No.
I acknowledge that he's present in court, and we will come to that issue down the track.
Sure. Thank you.
Your Honor, it's unnecessary for my name to be revealed. I'm not. Yes, here in my personal capacity. The court has power to control its own proceedings. Yes, this matter has previously been ventilated. Yes.
No, it hasn't.
The Court's Open Act 2013 does not limit or otherwise affect this order. There are precedents where in appropriate cases, counsel's names have been unidentified.
Yes, all right, just on that though, and I suspect this will be raised by Mr. Counsel. In those cases, what was the reason?
Yes, well, I'm not going to be able to assist Your Honor in detail with those.
Yes.
However, with respect to this application, for my name to be revealed.
No, for your name not to be suppressed.
Mr. Counsel, I ask you not to interrupt. You will have every opportunity like you do every time you appear before me. But I just ask that you don't interrupt counsel.
Sorry, Your Honor.
The precise reason why Mr. Counsel seeks to have my name revealed has not been articulated.
Well, I think what he has articulated is in the interests of justice, to be able to identify who counsel is to make inquiries about whether there is any relationship or other, or between counsel and the bench, or something else that might give rise to some perception of bias or...
That's entirely speculative. There is no basis for Mr. Counsel to consider that there is any reason that Your Honor could not bring an objective mind to this matter, nor to appear to do so. Now, the accused has stated in previous hearings that it may be his intention to add counsel's names to other proceedings. The prosecution understands that the accused has judicial review proceedings in relation to counsel and solicitors who may have been involved in this matter. Maybe in others, involved in other matters, either directly or indirectly. So, the situation might arise that if counsel's name is identified, counsel might then be conflicted if the accused attempts to instigate legal proceedings against them. This has occurred after other counsels whose names have been identified. So,
when you say proceedings against them personally?
Joining them as parties to Supreme Court proceedings.
Personally.
So, if counsel's name is identified, we have a situation where there may be a repetition of that, and counsel might be joined to Supreme Court review proceedings.
But he wouldn't necessarily.
I can only seek the court's leave, the Supreme Court's leave. Until the court gives me leave, they wouldn't be joined.
It could occur, though.
Mr. Counsel, please sit down.
It could occur, and then counsel presently appearing would be conflicted if it were to occur, and that could occur again, and again. That would frustrate the administration of justice and interfere with the efficient hearing and conduct of the matter.
But I don't recall, and Mr. Counsel will correct me, I'm sure. There's been quite a few hearings in this matter, and at this stage, I could be wrong. But I don't recall Mr. Counsel indicating, at least before me, any intention to add counsel's name to any proceedings arising from this matter.
Well, my instructions are that the accused has stated at previous hearings that it may be his intention to add counsel's name to other proceedings in the event that counsel's name is not revealed.
Sorry, can you say that again?
My instructions are the accused, as stated at previous hearings, that it may be his intention to add counsel's names to other proceedings, Supreme Court proceedings.
Yes.
In the event that counsel's name is revealed.
In the event?
It is understood. The accused has judicial review pending in relation to counsel and others who may have been involved in this matters directly or indirectly. And I'm trying to submit that the accused may seek to add counsel in Supreme Court proceedings merely by knowing their names. That would conflict counsel out of the present proceedings, and there may be a repetition of that. So, that every time a new counsel has to appear in these committal proceedings, new counsel will have to appear. Now that would be inefficient. It does not speak to the proper administration and efficient administration of justice. Now,
are you able to? I understand you're acting on, are you? Do you have any more instructions about when Mr. Counsel? But as I say, I don't recall him saying that. I'm not saying he hasn't, but...
That is the extent of the information that I have. Now my submission is he cannot suffer prejudice, if Your Honor is with me, that the revelation of counsel's name is not necessary, either for Your Honor to bring an impartial mind to the determination of these proceedings, or for the appearance of it. Then he is not prejudiced by reason of the failure for counsel to have their names revealed. In essence, it's not necessary for him to have a fair hearing.
Yes, counsel for.
Look, I adopt and reiterate the submissions of my learned friend, Your Honor, and I'd simply direct Your Honor to 3 cases. Sloan, S. Elowen versus the Queen, 2015, VSC 64.
Sorry, could I get the citation again?
2000 and...
2015 VSCA 64.
Thank you.
Malone, MLONE v. the Queen, 2020 VSCA 51. Crown v. Kamar, 2020 VSCA 103. Which are all identified as appropriate cases in which counsel's names have been unidentified. Right, what were the reasons?
I don't have.
That counsel's name I had identified in those cases, because there have been cases that I'm aware of where counsel's names have not been, have been. Counsel have been identified where there is perhaps a risk to counsel's safety, for example.
I'm at a disadvantage, Your Honor, because it was my understanding and instructions that this matter had already been articulated, and Your Honor had made a ruling.
Not in my case.
No, I think it had been I had. But again, I think it's going to be raised again.
It needs to be, yes.
That was different counsel.
I understand that, but...
As you could do this, Your Honor.
Mr. Counsel.
I'm just assisting the court, not my case.
Mr. Counsel, if I want your assistance, I'll ask for it. And I'll come back to you, all right?
Sure.
And I'm just trying to be fair to you two, so that different counsel are now appearing. I consider I have ruled on this before in relation to other counsel, but this is really a matter for individual counsel, and in my view, I don't think that there can be a blanket.
But that may well be the case, Your Honor. But the situation is that previous submissions were made. They were upheld by Your Honor.
Yes, they were.
And Your Honor made that ruling. I see there is absolutely no difference between our counsel arising, and in particular, my learned friend's point about the fact that every time new counsel is involved in the matter, we run this whole risk again of them becoming conflicted. I've certainly spoken to a member of counsel who's previously been involved in this matter.
Yes.
And that member of counsel has indicated that they were CC'd into an email to the Supreme Court in relation to a totally different proceeding. And that member of counsel felt that there was some kind of indication for a member of counsel that member of counsel may well expect to be somehow involved. There was no other reason to send an email directly to counsel in that instance. I can say that member of counsel has not to date been joined, or attempted to be joined in any measure, but that's the type of thing that my understanding is we're dealing with here, is where members of counsel have felt that it's necessary to take certain steps to try and identify themselves in their profession. And that's simply not appropriate. But apart from that, I simply adopt the matters that my learned friend has articulated, Your Honor.
Yes, counsel for.
Sorry, Your Honor.
Under protest.
No, but I don't think that the court should hear from the counsel from the LSB.
I've heard you on that, Mr. Counsel, and I've indicated I'm going to hear from him at this point, without making any final determination, all right?
Thank you.
Thank you, Your Honor. Can I reiterate that I appear as a member of the Independent Victorian Bar, not in my own private capacity. As a member of the Independent Victorian Bar, I have ethical obligations to check before I take brief that there is no conflict. My instructors have similar obligations when briefing me to ensure there is no conflict. Mr. Counsel will suffer no prejudice in this hearing without knowing my name. And as the matter currently stands, reasoning he requires, it is speculative, Your Honor. And I add that counsel for the Commissioner and Board has previously been attempted to be joined to the Supreme Court.
That's...
All right, yes. I think Counsel had something to say about that.
Yes. Perhaps I should not have raised that, Your Honor, but nevertheless, I otherwise adopt my friend's submissions. That there. Really. There is no prejudice that Mr. Counsel would suffer. I hope I might just make some further brief submissions. Your Honor ought to consider this issue in the context of what ought to be fairly routine considerations. Applications in respect of witness summons issue and applications to cross-examine the witnesses. These are not usually the sort of matters that apply.
It goes a ways, though, doesn't it? I mean, the similar argument can be made for Mr. Counsel.
Yes, well, usually, these matters are determined simply by analyzing the actual application and the merits of the application.
Yes.
The personalities, the individuals involved in the arguments, really have nothing to say.
That's right, yes, I agree with that. All right, Mr. Counsel, what's your? Do you wish to make a submission?
Absolutely. So, first of all, Your Honor.
Yes.
To contextualize the matter for everybody.
Yes.
What we have here is prosecutors appearing as officers of the court, as persons under obligations under the Criminal Procedure Act and the Public Prosecutions Act. Persons who have obligations, statutory obligations, of which I am the beneficiary. I am the intended beneficiary of those statutory obligations, and those persons who have the statutory obligations to me are unwilling to provide me their names. In a setting where the court does not have jurisdiction to keep the record of the proceedings from me or from anybody else. I have previously provided extensive submissions to the court. Those were simply for the court's assistance. The court ought to be familiar with those principles, and the principles clarify that under common law, there is no power of suppression.
Yes.
In fact,
there's nothing to suppress, though, because...
There is.
They haven't given a name to suppress.
No, it's part of the court record. What the court is...
Well, do you have any authority for that proposition?
What proposition, Your Honor?
Names are part of the court record. If they haven't given names...
Your Honor, how everything that the court let me start from the basics. The court must keep a record of who appeared before it, because otherwise it cannot hold counsel accountable. Nameless counsel cannot appear before the court, give submissions, and then go away without the court being able. The whole concept of having a special class of people that represent the rest of the people and are essentially gateways.
Can you respond, Mr. Counsel, please, to what the submissions that have been made by counsel for the DPP, particularly that? Firstly, that there is a concern that counsel's names will be added too. As far as, and I think I indicated this last time, this is a very minor issue, which I'm not going to waste a lot of time on. I don't consider that. This is not a Supreme Court review on these issues. This is a mention, which should be a short hearing. I'm giving you the opportunity if there is a good reason for you to have the names of counsel. I've given you the opportunity to make those submissions. But this is not a hearing where I'm going to go into the full merits of all of those arguments. But what's being said against you, and what's been said by counsel, each counsel, is that there is a concern that counsel's name, personal name, will be added to other litigation. Can you respond to that submission, please?
Sure, Your Honor. I was assured that I would be given time to address the court. I'm happy to address the court.
I'm giving you that time.
But I do not accept the false premise on which they want this matter to be decided. I'm happy to answer the question directly, but I request that I be given time to address some other issues as well.
I understand, Mr. Counsel.
Okay.
I'm asking you to direct.
Sure.
Your submissions to that issue.
Okay. So, Your Honor, Justice Janine in 2017 decided a case. The citation for the case is I'm just bringing up the do you have the submissions? So, Your Honor, the matter that the court decided was.
Don't worry about the cases. Just address. Can you just please address squarely the submission that's been made about?
Yes, I got it.
The reason why counsel are making the application that their names not be provided?
Yes. So, Your Honor.
Can you address that?
Yes. So, this morning, I started off by saying that this court did not have jurisdiction and I would not hesitate in bringing proceedings against this court if it made any decision that was unlawful.
Yes.
In 1946, one of the seminal authorities on the subject called Arthur Yates v. Vegetable Seed Company decreed that it is not the English view of the law that whatever is done officially is the law. It is the essence of the adversarial system that everybody is on trial. I have the case that I was referring to earlier. The case is Stewart v. Chief Commissioner of Police Victoria No. 2017 VSC 372. In that case, His Honor said,
All right, hold on. Stewart v. Chief Commissioner.
Of Police Victoria.
Police.
Number 2.
No, 2.
2017 VSC 372. The
VSC.
VSC 372.
All right, I can't write that fast, Mr. Counsel.
It's 372.
Yes, thank you.
2017 VSC.
Yes, yep, Stewart, all right. Well, what does that say?
The 41st paragraph of that.
Which paragraph?
The 41st.
Paragraph 41st, all right.
Reads, prosecutors and those who instruct them owe a duty to the court and may be held personally accountable if they provide the court with inaccurate information. Now I have made submissions to the court to Justice Janine about why I wanted to add the specific counsel that I did want to add. Essentially, Your Honor, misfeasance in public office has two important limbs. 1. The person who is being sued needs to owe a duty that was enforceable by the person to whom the duty would be owed.
Yes, all right, look.
So, in this matter, the court has been misled repeatedly. I have sent the Supreme Court an account of the number of times this court has been misled. Ms. Zhu has sworn an affidavit. We've had a number of arguments and debates before Your Honor, where I have alleged that the counsel was misleading the court. Justice Dixon in his decision has ruled that, Your Honor, if I may just complete, please. Justice Dixon.
Magistrate Williams, but you're not answering my question, mister.
I am answering the question. I'm saying that I do not need to justify my right because I have an entitlement. I deserve to know who the people appearing before the court are, because otherwise this is not really a judicial process. The court.
Well, you know that they are appearing as counsel. You know who they appear on behalf of. You haven't demonstrated to me any particular prejudice in the proceeding that's before me today. And unless you do grapple with the concerns, the specific concerns which have been raised by counsel, I'm going to uphold the application.
So, what? What concerns? I have already clarified that I suspect that they're misleading the court and...
All right, well, Mr. Counsel, let me put it this way. If on consideration down the track...
No, Your Honor.
You want to add counsel's name to some proceeding, there are mechanisms by which you can do that. But for today's purposes and in the interest of just getting on with it...
Well, I've not been heard. Let me clarify. I have not been heard.
Well, you have, Mr. Counsel.
No, Your Honor. Your Honor directed specific questions. I wanted to make submissions.
You haven't answered the questions.
I have answered the questions. You're asking me if they have a legitimate concern that they may be added to the proceeding. I'm saying yes, they can be added to the proceeding if they make any misleading submission, but that is not what the deciding matter is. The deciding matter is that this court does not actually have a legitimate authority to suppress their name, because the authority only comes from the Open Courts Act. There is no common law basis for suppression of any information that is known to the court. In fact, if Your Honor had discovered something about this proceeding, about the counsel appearing or so on, the court would be obliged to convey that information to me. If the court had any association, professional or otherwise, it would be a normal thing for the court to say that this is how I know this person, and so on and so forth. And then if there was a legitimate basis, the person can raise an objection or an allegation of bias.
Yes.
But the court cannot have any information about any of the parties that all the parties do not know about. And Your Honor, if I may just be heard for 5 minutes on the subject. All right, I'm going to.
All right, I'll give you until 11 o'clock.
Okay. No, Your Honor, it's 10 o'clock. It's 3 minutes to 11 at the moment.
Be fast then.
Your Honor, in Harmon v. Secretary of State for the Home Department 19831 AC 280, if a...
What was that case?
Harmon v. Secretary of State for the Home Department 19831 AC 280. It's the authority.
Slow down. Harmon v. Secretary.
Of State.
Yes.
For the Home Department 19831 AC 280. It's a House of Lords authority.
1983-1.
19831 AC.
Yes.
280. It's the authority after which the term the Harmon undertaking is coined.
Yes.
It was said in that case, so far as England is concerned, the principle that civil actions must be heard in open court was accepted by this House as being the established general rule in Scott v. Scott and is often referred to by the name of that case. Although most of the speeches were devoted to discussion of exceptions to that rule, in the speech of Lord Shaw of Dunfermline, however, is a useful quotation from Bentham that states the reason for the rule. It is not to satisfy public curiosity about the private affairs of individuals or have recourse to courts of justice for the resolution of their disputes, rather than each agreeing with the other to submit to them for arbitration. Nor is it even what might be regarded as a lesson-worthy reason to facilitate public discussion on matters of general public interest that may happen to have been involved in the dispute between the particular parties to the suit, as was undoubtedly the case in Williams v. Home Office itself. The reason stated by Bentham is that publicity is the very soul of justice. It is the keenest spur to exertion, and the surest of all guards against improbity.
Yes.
It keeps the judge himself while trying under trial.
Yes.
Now, that's a fundamental principle.
It's a fundamental proposition, Mr. Counsel, and...
Sure. Now
No one's arguing otherwise.
No, they are. What they're saying is that this judge cannot be on trial because there is no proper basis for this judge to be on trial. What they're saying is that there is no proper basis for me to suspect in this case that Your Honor could have any association with any of the parties. I accept that I do not have any basis, and when I made that point it was purely as an example of why I should be given an opportunity to access the court record, like everybody is. But, like that, every judge has the presumption of proper authority, of legitimacy, and Your Honor is no exception in that regard. Every judge in every matter in courts in Australia is entitled to respect and the presumption that they are a proper person to assess the matter. They've gone through a very extensive selection process. They have gone through all sorts of training. They're members of an exclusive community that is upheld in the highest regard. But there have been cases where those persons to whom the highest regard is presumed have been found guilty of all sorts of improper conduct. Now, it is against the notion of an accountable democratic system, which was elucidated in Lang and a number of other authorities by the High Court as being necessarily necessitating the right of individuals to hold every aspect of the government functioning to scrutiny.
Yes.
So, I cannot scrutinize the affairs of this court. There cannot be a proper report of what happened in this proceeding prepared if I cannot know what the names of the people are, or putting aside what the names are, what the information that Your Honor has access to. And I think at the heart of this is this fundamental question, whether this process is simply about whether or not I can be convicted. So, my interest is not simply in beating my conviction. I think I do not need much to achieve that. The reason why I'm involved in this matter is because I wanted to start an organization which was highly experimental and there wasn't enough commercial basis to justify the things that I wanted to do. What these cases have enabled me to do is fund the research and the employment into that experimental setup because they have abused the process relentlessly, and I've researched this matter extensively and employed people that do nothing else but look into the case law in this matter and are aware of every statutory provision that applies. And what I can tell this court is that this court does not have legitimacy if this process is not a process that can comply with what is said in Chapter 3 of the Constitution as being a judicial process. The legitimacy of this process comes into question, and the court does not have a right to
Yes.
The court cannot suppress my name. They have access to my identification. Well, counsel have just pointed to 3 cases where, no, those are the 3 cases that were in their original submissions. They said nothing about the principle. And in fact, Your Honor, I can explain why that had happened. In one of the cases at least, what had happened is, they wanted to suppress the name of one of the parties. And the names of the counsel were suppressed because it would have helped identify the parties by. I've been part of proceedings where suppression orders have been made. They have then suppressed everything related with the case, because if that is not done, then people can understand who the parties were, because they may know who the counsel saw. In one of the cases where the principle was clearly outlined, the principle was actually that they wanted to protect one of the parties. There was another case where the suppression order was made because the informant needed to be protected and therefore the lawyer's name was suppressed. It is ridiculous to say that this court or the judicial system here did not protect the lawyers. What? I'm not a criminal. I'm not a violent gang member. I don't peddle drugs.
All right, Mr. Counsel, can I just put this to you, though? This is not a substantive hearing. It's a mention, all right.
But this is a court of law.
Mr. Counsel, of course it is. But it's the return of subpoenas and an application to cross-examine some witnesses. As has been pointed out by counsel for the DPP, this is not a hearing. The sort of hearing where these sorts of issues are going to realistically.
They are not issues, Your Honor. They are not issues. They are.
Precisely they're not. That's right.
Yes, because it's not an issue. So, what they're saying is they're commoditizing justice. What they're saying is that I'm here to get a material benefit, so long as I can get that material benefit. What's the harm? Well, Your Honor, could be like that if a judge were to wear a Confederate flag for a tie in front of a black person appearing in court at the hearing in the United States. There would be obvious questions about the legitimacy of the judge, let alone the fact that that person was getting a fair hearing. There are certain fundamental attributes of a judicial process that cannot be violated. They are asking the court to violate that. The Vexatious Proceedings Act is an act that is at the recourse. If I'm bringing proceedings improperly, I have never been held to have brought any proceeding in the court, in any court in this country, improperly. I have brought several hundred proceedings, directly or indirectly, in various courts in this country. Never has there been an application to put me on the vexatious litigant list. I have brought proceedings against magistrates in New South Wales, in this state. I think over a dozen of Your Honor's brothers and sisters are recused from hearing matters of involving me. Never has it been alleged that I have abused that matter. Now, the fact of the matter is that if I start a proceeding against Your Honor today, then there's a good argument that Your Honor cannot hear these matters again. So, what they're arguing is completely facetious, because if that it was so easy for me to frustrate the judicial process, then the criminals would never see their justice being meted out to them. It is completely fallacious to argue that they need some sort of protection. They're not entitled to protection. They're here simply as officers of the court. The court can take preemptive steps against them when it is.
All right, but can I just say in response to that? I suspect what will be said is the situation arose in the course of the proceeding today.
Yes, I'm listening.
I'll wait until you finish your exchange.
Thank you. Yes, sorry.
That's all right. If a situation arose, there's no reason at all to suggest that there's just not. Never did. There are steps that you can take. But for today's purposes, I can't see how you are prejudiced in any way by not knowing the names of counsel.
Well, Your Honor, I will just quickly advise the court of an authority. And this is an authority involving Guard as the solicitor. Jarrod Wilson.
Yes.
What happened in that case is that.
What's the name of the case?
And that's the citation that I was asking my associate to assist with. And for the record, several of my assistants often live with me because I have a home office and I require people to be working for me continuously. And that's the context in which Ms. Zhu resides at the premises where I reside. This is the one, I think. So, yeah, I'm getting the citation, but I'll just deduce the principle in that matter.
Yes, because they were refusing to testify against a former client in a criminal matter because they were afraid of their. I'm aware of the case, yes.
So, ultimately the Court of Appeal so the Supreme Court held them in contempt. The Court of Appeal ruled that so the Supreme Court held them in contempt because it was expected that they accept the threat to their life. They had refused to testify because a person close to them had been killed.
Yes.
And they were of the view that the police was sick powerless to save their life. The court still expected them to produce their name because they were an officer of the court.
But it's a bit different, isn't it? Where somebody's given.
That's the most extreme case.
But Mr. Counsel, that was a situation, as I recall it, where the person was giving evidence.
That's not the point. The point is that...
Well, that is the point.
No, Your Honor, if I may be heard with an open mind. The point is that fundamentally, what they're saying is one of two things. Either the name should be suppressed because I can exploit it to cause delays to this proceeding. Now, that's an erroneous argument because I can simply start proceedings against Your Honor and then this proceeding is delayed. So, also, as Your Honor pointed out, I don't need their names to add them to proceedings.
Well, you have done. You have brought proceedings against numerous magistrates.
Absolutely. But never has it been done improperly. Never has it been found.
I'm not suggesting that it has, but...
And in fact, the court has criticized Your Honor's, well, at least one of Your Honor's sisters, for being unreasonable with me. I have the transcript with me. I can provide it to the court. In other matters, I have never lost a case that I've brought in my name in relation to the magistrates in this state. Your Honor, the point that I'm trying.
No, I haven't seen. Read any that you've won, Mr. Counsel.
Because they are yet undecided.
Right, well, but that's right. But it's one thing to say I haven't lost a case. It's another thing when they haven't been decided.
Yes. No, Your Honor, because I had the presumption of legitimacy. What they're saying is that I don't.
But no, they're not saying that.
But yes.
They are.
They're arguing. They cannot be arguing.
The point they're making is you are very, with all due respect, and I'm not being critical, you are exercising your rights, but you are a very litigious person.
That's an improper statement.
Well, you are.
No, I'm not.
And you said that yourself?
No, I've said that I've been responsible for a number of cases through entities and myself, but my entities have thousands of or tens of thousands of transactions with various people, and I do not tolerate nonsense. That's all it is.
All right.
Where people?
Well, I think you've had more than enough time.
No, I haven't, Your Honor. Well,
Mr. Counsel, you've had plenty of time. This is a preliminary issue. We haven't even got to any.
No,
Why? Counsel is here today.
But the second matter that I wanted to raise.
And it's already 11:10, so.
Your Honor, I cannot continue with this matter if the court is unprepared to give me the name of the counsel. The court has no power to suppress the name of the counsel or to keep any information.
Look, it's not a matter of suppressing. Counsel's names haven't been suppressed.
But you have information.
But there is nothing to suppress.
Okay, you have information that I don't. It's not a fair process.
I have information.
You know their names.
I might know their names just through having worked in and around.
And that's why it's especially important that I know their names, because I do not know how you worked with them.
Well, because.
And this is not about you, Your Honor, to clarify.
I understand.
It's not about you. It's about the fact that the reasonable apprehension, there is, Your Honor, this is a new argument in Edna, the test for reasonable apprehension of bias was expressed as a double test. So, all that needs to be said today is that if it was conceived, if it was reasonably conceivable that any reasonable person, one reasonable person, could think that normally a magistrate would give the name. Why is this magistrate not giving the name? Or allowing a scandalous application like that to persist? The second matter, Your Honor, is the matter of the Charter of Human Rights and Responsibilities.
All right, what do you want to say about that?
I have the right to equal treatment before the law. I can make extensive submissions about what the meaning of that term is, but basically what that means is, if there is a generally accepted norm of conduct, in terms of court practice, in order for the court to vary from that conduct, the court must have very good reason, because the presumption.
Can you point me to where in the Charter you're referring to?
The right of equality before the court.
All right, and are there any cases of that?
Yes, there's Castles v. Okay, let me just bring up the matter. So, Your Honor, there's Ragg v. Magistrates Court of.
Yes, look, I'm very familiar with that case.
Equality of Arms and S38 of the Charter. I have a physical copy of it for the court. There's X7 v. Australia.
All right, just take a seat, Mr. Counsel.
But may I just fully develop this argument before, because...
Yes, all right, well look, I think it's now 11:15. We're not going to get through we've allocated 3 hours for this matter. Mr. Counsel, you've already used 1 hour and a quarter, all right?
I haven't, they have.
You were late to start with, and then so you.
Your Honor, I was late because, well, precisely in anticipation that this would happen. I was trying to get to the Supreme Court because I have written this to the court yesterday.
No, I'm not interested in the reasons at the moment. Mr. Counsel, you have been late every single time you've appeared before me. You were late again today.
Your Honor cannot okay. That is actually a bias. What Your Honor's presuming is that.
It's just true.
Yes, but you're presuming that because I was late on the previous instance, I will not have a legitimate basis to be late this today. That's a bias.
I'm just making an observation, Mr. Counsel.
Your Honor is expressing Your Honor's view about the tendency that Your Honor feels that I have.
Well, it's just simply an observation that you are late every single time.
Yes, that's the tendency.
Magistrate Williams, well.
That is the tendency, undoubtedly.
Perhaps it is, but...
So, Your Honor is convinced or is suspicious of a tendency on my part.
No, it wouldn't have mattered who it is. If any litigant before this court is constantly late, it's going to cause the court.
I'm not a litigant before this court. This court does not have jurisdiction in this matter.
You are a party.
Yeah, I'm not a party. I'm here because the court is threatening me.
No, you're an accused, Mr. Counsel. You're on bail.
Your Honor, I'm not legitimately an accused. I'm only here because the court is extorting me.
All right, what else did you want to say on this point?
What I want to say is that under the right to equality before the court, if the court, and let me also remind the court that this is actually an administrative process, the committal process itself is an administrative process. So, apart from the right to equality before.
I'm aware of that, Mr. Counsel.
Okay, so, apart from the right to equality before the court, S38 of the Charter also applies. S38 of the Charter, that only applies to administrative processes, requires this court to consider the impact of every decision it makes on my human rights.
Yes.
On my human rights.
Yes.
And what it requires is that wherever there's an ambiguity, wherever the legislation is not perfectly clear, the court has to interpret that legislation as being...
Yes, I'm well aware of all of that, Mr. Counsel.
Okay, so, undoubtedly, it is better for my human rights if the names were known to me. If nothing else, it would give me some confidence. It would have avoided this delay.
Well, it would, the counsel. I must say, I think Mr. Counsel has made some points which have some force, particularly the last point. Do counsel wish to respond?
Yes, nothing Mr. Counsel has said should alleviate the true concerns that he may seek to join counsel in other proceedings.
But isn't that his right?
However...
And he makes the point? He is merely exercising his right as a citizen to do that. And why shouldn't he be able to exercise that right?
So, as I understand it, he says he requires the names in case the court is misled.
Number.
As I understood it?
Yes.
Now, nothing has been said that could potentially be seen as misleading.
But I suppose, though, the ordinary position is that counsel's names are entered onto the record.
Yes.
That's the ordinary position. Your application is that does not occur in this case.
That's right.
And the application brought by one of whom Mr. Counsel does not accept his standing. So the onus is on you to satisfy the court why the usual process ought not apply here. The point Mr. Counsel has made is, well, another case in this state, ordinarily, unless there's some basis such as what is he has, such as the circumstance where he has pointed out that the identification of counsel may lead to the identification of somebody whose name is suppressed.
Sure.
In absence of good reason. Now, I must say, and I think no one's pointed out otherwise, I don't recall Mr. Counsel saying previously he will join counsel. But he's indicated today he will say to do so if he perceives that there is some misfeasance or basis, and that's his right to do that.
And there is as yet and may never be such an appearance.
Number.
And therefore, there is no need.
Doesn't that go the other way as well?
It doesn't matter either way, is really the point. He suggests essentially that there needs to be scrutiny, and counsel's names are required in order for him to exercise some sort of scrutiny over the proceedings. There's actually very little to scrutinize so far. We have not got to the substance.
Well, that's right, but that also goes both. Cuts both ways, doesn't it?
I accept that.
Yes.
But the reality is, Mr. Counsel has remarked that he has litigated hundreds of matters.
Yes, he has.
Mr. Counsel has.
Same time. Takes umbrage if I described him as litigious.
Yes, because that implies, Your Honor, with respect, that I have done that without and...
No, it doesn't.
But there's a counsel who's sighing repeatedly. It's extremely improper. And let me just clarify, it was said earlier to the court that there has been... No, sorry if she keeps sighing. I should know her name, because this is actually disrespectful to the court.
I didn't hear any sighing. Mr. Counsel, can you please take a seat? Counsel's making a submission.
No, Your Honor, I just want to raise an objection.
Yes.
Because there are a number of factual matters that are put to the court, including a hearsay conversation with another counsel by the counsel that I alleged was sighing repeatedly while I was submitting matters to the court. The fact that Your Honor was previously told by Miss Amber Wilson, or Harris, Miss Amber Harris, that there was no video. And then Miss Amber Harris later apologized to this court for giving the court erroneous information. The fact that the informant in this matter has certified for times across the two matters that...
Has this got anything to do with what we're talking about at the moment, Mr. Counsel?
Yes, because the counsel just said that there has been no proper basis to allege that there's been misfeasance by counsel, and it.
So counsel was mistaken. That happens.
Yeah, but when that happens, I have a right to raise an allegation that that mistake should not have been.
Look, I'm agreeing with you, Mr. Counsel.
But they're saying that there's never been an occasion in this proceeding where I could have legitimately argued now what needs to be.
Seriously, I'm listening to counsels.
Sure, thank you.
Response to those submissions. You've made those arguments. I'm listening to counsel's response. I'm giving counsel an opportunity to respond.
Sure, thank you.
Thank you.
As I was submitting, it appears Mr. Coxell's argument is that he requires counsel's names in case there is something that is done that is misleading. My submission is I have not done anything or said anything that should raise the concerns that he requires my name and the potential that he joins me to a Supreme Court proceedings. And my submission is that is a real potential. And his perception of what may be misleading is perhaps not clear. This comes in the context of Mr. Counsel remarking that he has litigated hundreds of matters and remarking that other magistrates had recused themselves. Which comes back to my point about the undesirability of the potential of Mr. Counsel joining counsel to Supreme Court proceedings, counsel being conflicted, new counsel coming in. As I say, in respect of his submission that there needs to be scrutiny. As I say, we haven't even got to the substance of the actual applications. There's been nothing, in essence, to scrutinize.
Number.
What about counsel that I hear only for one application? The LSB counsel is here for just one application. That argument folds away for those.
Mr. Counsel, please take a seat.
I have completed my submissions in reply. Your Honor.
Thank you.
I ask that we, and again, I adopt my learned friend's submission, and add one thing. One of the main concerns, it appears, that Mr. Counsel raises is the issue of Your Honor's familiarity with the parties at the bar table. Quite clearly, Your Honor, as a judicial officer, would have a positive obligation to bring that to the attention of any accused person. In my respectful submission, that has the least amount of merit of any of the arguments that Mr. Counsel puts forward.
I agree with that.
And I'm simply again, as I say, I adopt my learned friends.
Look, I must say, and I address all counsel, I do have a bit of a concern. I understand the submission that, and I understand the reason why counsel are making the application. But I do have a concern about the court using a power under us 136 of the Magistrates Court Act, which is a power which the court has to give a direction for the conduct. So I'm just lost looking at this section now. And I'm expressing this because just in the interest of transparency, that's the sense of unease I have about it. That whether that's appropriate that the court's power to control a proceeding be used in that way.
I simply ask the question of what is the right that's been served here. But,
well,
I know we've heard a lot from Mr. Counsel, but what is the actual right of knowing counsel's name with respect, Your Honor? I don't see that particularly having any right. How does it frustrate his ability to prosecute his own matter?
Well, I can understand. Well, any other case counsel's name is given.
Yes, and in any other case, counsel isn't facing the risk of being marched over the road for something that they say is inappropriate.
Well, they are. The point Mr. Counsel would say is, well, they are. That could happen in any case. Anyone can come to the court, make submissions, and then go and get legal advice. And that advice might be, well, I can't imagine that it would happen very often. But I suppose it is. That's what could happen in any case.
Yes, but this is a particular case where there is a greatly heightened.
Now, well, I'm not sure about that, because it hasn't happened in this particular case yet. Well, I'm not sure about that, because it hasn't happened, It hasn't happened in this particular case yet.
Well, there's been a threat of it, Your Honor, back in July.
Sorry, Your Honor. This is evidence. The court cannot accept. I'm objecting formally.
All right, I accept your objection. Take a seat. Thanks. Sometimes evidence can be outlined from the bar table. If you object to it.
I am objecting to it.
I understand I'm not going to prevent counsel from making a submission and referring to evidence in open court.
Sorry, I didn't say it in open court. If they're attributing it to me.
We don't know what counsel's going to say yet.
Okay.
She hasn't said it yet.
She said there was a threat made. I presume she was not complaining about one of her.
We don't know what she's going to say, Mr. Counsel.
Sure, thank you, Your Honor.
Just listen to what she's going to say, thank you.
It's simply a demand to the reception at the Victorian Government Solicitor's office, demanding a name of a Victorian Government Solicitor who is instructing in this court of a date in June. As I am, and the words of Mr. Counsel are I'm commencing a proceeding in the Supreme Court of Victoria, of which I...
Sorry, Your Honor, this is an objection.
Tend to seek to clarify fully.
She's reading a court.
In relation to the anonymous VGSO solicitor's professional conduct.
So what are you reading from?
I'm reading from an email that was sent to the Victorian Government Solicitor demanding the name of the person who had been obviously given leave by obviously. I wasn't involved, but a solicitor who'd been given leave not to provide their name. He then writes to the Victorian Government Solicitor.
So, Your Honor, I object.
Demanding their name in order for him to take proceedings in the Supreme Court.
What's wrong with that?
Well, again, this is what all counsel face, and obviously, solicitors embarrassed.
Counsel face that in any case, don't they?
Yes, but Your Honor, this is a particularly unusual case. And Your Honor's already said that where a person takes out literally hundreds of proceedings against courts, magistrates, court staff.
Sorry, Your Honor, she's alleging that I've taken out proceedings against court staff.
I'm not aware of any proceedings where there have been proceedings against court staff.
Your Honor, what they're saying is that the court should find that.
All right, just take a seat, Mr. Counsel.
Your Honor, I just say this, because this is I have a right to reputation in Ainsworth v. Crime Commission, Queensland. The High Court ruled that the court must be conscious of the reputational aspect of parties before it and others, and everybody should be able to object to scandalous submissions made, which are an abuse of qualified privilege.
Look, I think it's probably a bit of overreach by counsel, because I agree with you, but the point that she's making is that there's been a number of proceedings which have been brought by you, Mr. Counsel.
Absolutely, and I was upfront about it. They're saying that on the basis that I told the court about that, because there's nothing improper about that. Your Honor, it is the English view of the law.
All right, thank you.
That everybody.
All right, you've made that point, Mr. Counsel, thank you.
And in fact, in Arthur Yates.
Take a seat.
They criticize systems where that was not.
Mr. Counsel.
Sure.
Thank you, sorry, for the interruption. Was there?
I don't think I've got anything further that can help. Your Honor.
What about yes?
Your Honor, I understand counsel's names are put on the record as a matter of routine. It's my submission that this is an administrative process. This does not affect the legal or substantive right of Mr. Counsel.
Yes.
Withholding these names do not affect his legal capacity to conduct these proceedings.
Well, how does he conduct, say he doesn't want to, and I'm putting this, I'll just make this point. Say he wanted to, after today, bring a proceeding against a member of counsel. How does he do so?
Why should we go forward on the basis that he has a potential right of claim against members of counsel? We haven't heard any argument yet. Theoretically, legally, it may be possible that he might seek to litigate against the director, against the commissioner, against a number of bodies. There has been no good reason put forward for why he ought to have the potential to seek counsel's names.
No, but the onus is on. The onus is on you. And this is the... He does. It's not onus. He doesn't bear an onus. This is the thing.
And I've been at pains to point out the reality is, there may be a, if I might say so, potentially high degree of reticence. Mischievous application to join members of counsel in other judicial applications, to join members of counsel in other judicial proceedings. In circumstances, again, where we are talking about whether witnesses ought to be cross-examined, why must this occur?
Well...
May I help the court?
No, Mr. Counsel, Please, I'll come back to you if necessary. Please sit down. It's now 11:30.
But, Your Honor,
Number.
just one sentence.
No, Mr. Counsel, sit down.
I'm afraid I'm exhausted.
I understand. Look, I am not persuaded that counsel's names shouldn't be disclosed. Yet I think while the court does have a power to make directions under S. 136 of the Magistrates Court Act, there needs to be a good reason to exercise that power in the way that it's been sought. And I think the submission that's been made that that there's a procedural administrative hearing, which it is, cuts both ways. And in those circumstances, in my view, it doesn't. And also, the other point, I think, is that if Mr. Counsel was determined to add counsel to proceedings, he could do so anyway. There are mechanisms by which he could do that if he wanted to. I am concerned about that power under S. 136 being used for an improper purpose. I am not sure whether it is a proper or improper purpose. I am not making any finding about that either way, nor am I making any finding about whether it forms part of the court record.
May it please the court.
I'd ask the matter be stood down for a moment. I need to get some instructions on that ruling.
Yes, no, that's all right.
Thank you, Your Honor.
I thought that might be the case, so.
May I say one thing for the court record?
Yes.
At no point did I ever allege that there was a basis to suspect that this court had any improper association with any party. I think the counsel tried to twist my argument. What I was saying is that the adage that justice should be not only done but seen to be done has a very high bar. So every judicial officer should be able to be scrutinized. And there was no basis to suggest that this judicial officer was any more.
No, I understand that, Mr. Counsel. So I refuse the application for counsel's names not to be. All right, that deals with that.
Thank you.
All right, counsel. Before counsel have rights to appeal rights as well, or the parties they appear for have rights.